American for Molecular Pathology Association against Myriad Genetics case in the Supreme Court that was resolved in 2013. And the reason that I choose this case is because it gave me, to me, was like a summary of the course. It touched a lot of topics that we taught in course, and for me it was a great learning experience. And another reason I selected this case is because when I first read it, the case opinion for the internet, it was a very specific, very easy to read court opinion. It's on the first 4 pages of the opinion. It summarizes to me a whole biochemistry textbook. I mean, it was very easy to follow, and I very liked it because and it's a very case to learn in the patent course, IP course. To begin with, how did we get to Myriad, to AMP versus Myriad? Some events and gene patenting case. One of the hallmarks of a gene patenting case is a Supreme Court case, Diamond versus Chakrabarty, which I'm going to talk a little bit in the next slide. First gene patent issued to the University of California in 1982. 1991, the NHI started filing for patents of short segments of DNA. But it wasn't until 98 where the first patent was awarded to not only NIH but other organizations, and actually Myriad genes. The Myriad genes that we're going to talk about this case were patents were issued in that same year. And what happened through that year that caused this gene euphoria about the years is that in the 2000s, the genome project was finalized and was published in the major journals and was made public. And from that on, of course, biotechnology rose, and one key issue of patenting case didn't occur here in the United States, it occurred in the European Union, where they cut short some, or they limited patentable rights to once these Myriad issued patents. And it's not only the courts here that are very stringent with patent laws, it's also in the EU, they're very strict. And then, of course, in 2009, the case that I'm going to talk about was first filed in the federal court. Another bit of history about gene patenting cases that has gone into the Supreme Court dates, well, not gene, but biology that are related to biology, dates back to 1874. Here's one of the cases. I'm not going to talk very deeply, but this, of course, I want to talk a little bit about this one because it's mentioned in the court ruling about Diamond versus Chakrabarty, which they awarded a patent to a plant that had a plasmid inserted into the DNA of a microbe. So that was determined to be an invention because the type of this microbe had this artificially plasmid inserted into them, and the Supreme Court did upheld that patent that was issued by the United States Patent and Trademark Office. What brought this case into the federal courts? The history behind the background about it is that Dr. Harry Oster, he worked at the NYU School of Medicine. He made routine gene tests to his cancer patients, mostly women with breast cancer issues. He routinely sent samples to a laboratory genetic diagnostic labs in University of Pennsylvania. They routinely sent those tests, and Myriad got notices about these activities because they were looking at the same genes that Myriad had discovered. And I'll talk about well, these are the genes, BRCA1 and BRCA2 genes. So these are the DNA segment that Myriad isolated in order to develop the test for breast cancer and ovarian cancer patients. And when the Dr. Osper found out that the lab was no longer going to take the samples, he and another advocacy group, they got mad. So they joined groups and they decided to file a case in court. And not only there's so now we're starting to an issue where biotech companies lobby to Congress to advocate for patents in gene patents. Well, then there's the other side of the group who would believe that life instruction cannot be controlled by legal monopolies. So there's the two sides of the scene on the Supreme Court cases, and the main concern and the main issue that this patient arises is that one of the main issues is that Myriad's monopolies made the breast cancer, ovarian cancer tests very expensive and unaffordable. That's one of the key issues of what brought this case into the courts. Like Michelle said earlier, these courts started the district court, and in the district court, they invalidated all of Myriad's patents. Invalidated all of them. Right? But I jump into the Circuit of Appeal case where Myriad jumped in right away to countersue, to appeal, because it was on this stage of the lawsuit where the interesting issue came into light. To describe what happened, we have to understand that the Circuit of Appeal is composed of 3 members, 3 judges. And each of the 3 members, even though it has to be a 2-to-1 decision, each of the 3 judges had different views of why they issued their opinion. Of course, the 2 of them that agreed didn't really agree on why they issued their vote that they did. So we're going to go more into what happened. So the first Judge Lurie, she was in favor of giving of holding the patent to Myriad, because for her, the genes that Myriad patented were not a product of nature. And the basis for her to determine that is that she believed that because Myriad had to deliberately had to cut the gene segment, and then in order to isolate the segment of interest, which are the BRCA1 and BRCA2 genes, that's not naturally occurring. That's the main reason she decided it was not a product of nature. But she acknowledged, the problem is that she acknowledged that even though Myriad had to deliberately cut the gene, the DNA segment, the covalent, the chemical bonds that are here, she acknowledged that that segment that was cut had the same encoded DNA information as the natural occurring genes. So even though it's a cut short, it has the same information where it came from. I mean, it has the same information of the large DNA segment where it came from. But for her, that was irrelevant in terms of, for her, it still was an invention. And an important note to understand is that this the judge has a PhD in chemistry. So just have to keep that in mind for why she made that decision. Then came the second opinion of Judge Moore, which agreed with the first judge that these genes are not a product of nature, therefore entitled to a patent, but not because of the issue of the breaking of the chemical bonds, which was the basis of the Judge Lowry decision, but she invoked the custom of the custom of the USPTO to award gene patents regularly, and we talked this in this class about with Dr. Schein, which he mentioned this is called the deferment principle. Well, normally the courts tend to agree with the government agency decision. And we'll talk this later on in the Supreme Court case because they gave a very definite answer to this question. And then they came the dissenting opinion of the third judge, Judge Bryson, which for him, plain and simple, said it is a product. I mean, he didn't say exactly a product of nature. He said that Myriad didn't invent anything by isolating the genes. For Judge Bryson, he said that isolating genes is what's commonplace back in. It's a common procedure for genes. For the genes to be done, and for him, he even said in his opinion that there's no magic in gene isolation. So for him, there's no invention. So he believes that this patent should not be awarded to them. But all three judges did concur, and I will mention this later on, that cDNA, which is the combination DNA, which I'll talk a little bit more further on, all three concur that it was not a product of nature, and it had to be, a patent can be awarded to it. And I'll talk a little bit further why. Now, the case came to the Supreme Court, and these are, of course, the 9 justices that were back then in 2003. And of course, I wanted to highlight Judge Clarence Thomas, because he was the judge that wrote the decision for all 9 judges who decided unanimously in this case. And I wanted to, one of the key characteristics of Judge Thomas is that, for what I've read in the past, I remember when he was nominated by President Bush, when he had the issue with his nomination. But my experience